Hello everyone, I Khushbu Nathalia on behalf of Conceptual Legal Family welcome you all for Hello everyone, I Khushbu Nathalia on behalf of Conceptual Legal Family welcome you all today for our live session on women's right for inheritance and succession laws in India. And we have a very special guest with us, Ms. Kadambari Suri ma'am. Ma'am is an eminent litigator, arbitrator, and a mediator. Madam is acting as a standing counsel for NDMC and is also designated as a Senior Panel Counsel by Union of India. Ma'am has represented various Indian, foreign, PSUs and individuals and is also holding independent director post in few companies. Ma'am, we extend a whole heart welcome to you.
Thanks, Khushbu.
We have assembled here today for a live session on an analysis of succession and inheritance law for Hindu women in India. Women for long have been subjected to discrimination and is being treated as a vulnerable section of the society. She has faced discrimination not only in the society in general, but also within her own family in particular. Recently, the women have been given the status of being equal co-partner in the landmark judgment of Vineeta Sharma. Before we actually launch into the rights of women and talk about the impact of the recent judgment, I would request ma'am to clarify some of the important terms and the basic terms associated with inheritance and succession laws, such as who is a co-partner, what exactly is co-partnery, what is joint Hindu, what is partition, what is Hindu undivided, and what is the self-acquired property, what is an inherent property. So, ma'am, if you may please throw some light on these terms so that it becomes easy for the viewers to understand the judgment and the impact of the same.
Thank you, Khushbu. And it's a pleasure to be on this platform. And whatever expertise I have in this particular domain, which is very vast, I'll be happy to share it with you and the viewers. So you asked about certain terms like co-partnery, ancestral property, what is a separate property, and the related terms. So let's start with what, so let me just clarify before getting into the discussion. Some of these terms, especially the concept of ancestral and HUF, is still under a state of deliberation, because we find even now, after so many years, also we find certain conflicting terms. Perhaps this is because the law has undergone a change, an evolution over a period of time. And especially now with Vineeta Sharma's case, the judgment which has recently been delivered by the Honorable Supreme Court, and various amendments which have happened. So the terminology and the relevance of these have also undergone a change. Now let's deal with co-partnery and what are co-partners. So if you define co-partners, they are those people who acquire by birth an interest in the joint property or co-partnery property. As per the Shastric Hindu law, there was a presumption of jointness of a Hindu family. And a co-partnery is formed from the members of 4 generations who are considered as sapindas. So sapinda is the term used for blood relatives, and the 4 generations. So basically, the 3 generations next to the holder of a particular property in an unbroken male descent. So when I say holder of the property in a joint family property, the holder, which is the karta, will not necessarily be treated as the owner, because the ownership belongs to the joint family. Now, earlier, only male members of 4 generations used to be considered as co-partners, and the property used to devolve. Now, there are 2 different schools, and I'll come to that later. But earlier, only men used to be considered as the co-partners, and now, after the amendment of 2005, women were also, the daughters are also included in the definition of a co-partner. So daughters as well as sons, they will be co-partners subject to the 4 generations condition being satisfied. Now, the essence of co-partnery is community of interest, a unity of possession. So they hold the property in a united way. The ownership is vested in whole of co-partnery, and no one co-partner could claim that he has a definitive share. So his interest will be fluctuating as long as the property remains a joint property, because the more children would take birth, the more there will be a division of the share. The share will go down. So it will be a fluctuating kind of a share. And nobody can claim rights to a particular piece of that property until there is a partition. So when there is a partition, then till there is a partition, they will hold it as joint tenants. But after partition and after definitive shares are delineated, then they will have specific shares and they will be called tenants in common. So therefore, till the segregation takes place, it continues as joint. Now, regarding under Hindu succession laws, there were 2 major schools, Mitakshara and Dayabhaga. We will come to these 2 schools later because they also evolved over a period of time. When we talk of ancestral property, now if we define ancestral property as a property that is inherited, again, it's an inherited property, and if it comes after one generation dies interstate and it falls to the legal heirs by way of succession. Now there is again a conflict between the various judgments rendered by the Supreme Court and various courts with regard to the character of ancestral property, whether it would be deemed as HUF or whether it would be treated as separate property. Now, separate property, I will come to various judgments also, which the Delhi High Court, Supreme Court, and various other courts have given in this regard. I'll just touch upon those judgments just to clarify what is the conflict about. Now, separate property is a property which either you earn by yourself, a male or a female, they earn by themselves, or it is inherited from collaterals, or from say earlier it was said that property inherited from a woman is also a self-acquired property. A property which comes to you by way of will, somebody has, your father or somebody else has willed it to you. And also after partition, the courts have considered that even when partition takes place, you partake of your share as in the form of a separate property. So now there is a controversy, as I said, on whether separate or self-acquired property, once it descends to the heirs of the owner, whether it remains ancestral or rather whether it converts into HUF in the hands of the inheritor and his male or female issues. Now the issue has this issue has the Delhi High Court has taken an opinion. In fact, late Justice Valmiki Mehta had in Shri Gyanchand and others versus Shri Ramchandar, the court had observed that mere inheritance cannot make a property as an HUF property unless the property was inherited either prior to the Hindu Succession Act 1956 or it has been put into a common hodgepodge. Then only it will acquire an HUF character. Now, this judgment was based on the previous Supreme Court judgments, such as Commissioner of Wealth Tax versus Chandar Sen. There is one judgment, and Yudhishthir versus Ashok Kumar. So these were the Supreme Court judgments wherein the Supreme Court also held that after passing of the Hindu Succession Act 1956, if any property is inherited by a male person, by now of course daughters also, from his ancestors, he will inherit the same as self-acquired property and not HUF. However, as I said, the conflicting judgments are still to be resolved, and there are various high courts and even Supreme Court judgments which are conflicting in nature. Now, partition. Partition is again a terminology which people would do good to understand when we talk about Hindu Succession Act. So, partition means severance of the joint status, and it's the determination of the share of co-parceners in the joint property. And partition need not be an actual partition, physical partition. Once the intention is conveyed to the other co-parceners by one co-parcener that you want to partition the property, that unequivocal and definite indication will immediately lead to partition. So the severance of status takes place from the time when you communicate your intention, and not when it is received by either the co-parceners or the karta, etc. So as I said, now both sons and daughters are co-parceners, which was till 2005 something elusive to daughters, and there has been a long history with regard to that. I hope I have covered all the definitions the terminologies that you wanted to ask.
Yes, ma'am, you have covered all the terms and you have covered it very beautifully. As you've just pointed out that the they were not given the right of being a co-partner up till the 2005 amendment, which we see in the Succession Act, Hindu Succession Act. But before we actually come to that, we would like to know about the historical background of the same. Like, we have started with the Navratri, auspicious occasion wherein women are treated as goddess. They are being worshipped. But if we see the ground reality, that is something really different. So what exactly has led to this reality is something which we want to know from you.
So Khushbu, if we talk about historical status of Hindu women, I would say that firstly, it is not only about Hindu women, but women the world over. If you see the historical evolution in the UK or the United States of America, you would find that the women as a class have struggled to gain that equality, that elusive gender equality. And if you closely look and analyze the reasons, you will find that the rights of women or any section or class of society which are getting crystallized or better or abrogated over a period of time, either which ways, have a direct cause and effect relationship with economic exigencies of that period. In fact, intrinsic economic relevance is what I feel primarily defines the social as well as legal status. Now, in the Indian context, the position of women had been better or worse, again, as per the economic milieu obtaining at that time. The role they had to play vis-a-vis men. Let's start when the societies were still in the nomadic, pastoral kind of a stage. So initially, one finds that most of the societies, especially in India, had a predominant matriarchal character when they were still nomads and they were pastoral. So they would move from one place to another, and the possessions would be movable. So there was no concept of immovable properties. Now, so if you see the matriarchal references can be found in the Vedic texts as well as till as late as Mahabharata. There are references to sons being addressed by their mother's name, Kunti Putra or Gandhari Putra, in that manner. In fact, Patanjali, there is in Patanjali's commentary of Charaka Samhita, he says that there is an honor in being addressed by the mother's name. Then there is one of the Upanishads, Bradyanka Upanishads, where it says that the predominance of a woman gives rise to meritorious sons. Now, even when we talk of marriages, so when we say that Hindus always had a very patriarchal setup, well, it evolved later. And earlier, even when marriages used to take place, so out of 4 kinds of marriages which were there, only in one kind of marriage, which was Brahma marriage, a woman was supposed to join the sapinda of her husband and leave that of her own fathers or family. And in the rest of the marriages, in fact, there are commentaries to suggest that she would continue to be a sapinda of her father's clan. So if we derive sapindaship to coparcenary, and if you see the traditional the very, very original references to Hinduism, you would find that women did have same or even higher status as far as their role, the social status was concerned. Now, gradually, as land acquisition, the agriculture became the main economic activity. There was land acquisition, there were wars to acquire, the strength was required to clear forests. Then there were wars over acquiring different lands from different tribes or protecting your own. So women started requiring protection. So her economic role also became lesser because agricultural activities required strength. So I would connect these declining social status or a superior social status purely on what economic value you bring to the table. Now, it was around this time when you see a shift in terminology. So gotra literally means cow pen. So it has a pastoral connotation. Kula is now Kula means root. So the agriculture was playing an important role. Now, thereafter, there was a socio-legal, when societies got settled, the Hindus' Shastric laws started developing. We find that there were four major sources that came and, how they evolved. So first, Hindus believe that there were Shrutis, which to hear, there were Vedas, Vedantas, Upanishads, Vedantas, and all of that. So Hindus feel that these are the divine revealing from the God. What we have got as laws and socio political guidance is received, is divine. Then there were smritis, which were the remembrances, which actually gave the morality and procedural and substantive rules and all of that. Over a period of time, customs came to what was the practice and custom. They became the primary source of interpretation and implementation. And in fact, they acquired a superior position over smritis and shrutis and the written texts also. Thereafter emerged the commentaries. When we say commentaries and digests, now we come to various schools of thought. Like we come to Mitakshara and Daya Bhaga. So Mitakshara and Daya Bhaga both relied on the smritis, which were written and which were passed down from centuries and interpreted and went through an evolution. Now let's see the women's property in this context. Initially, when movable property was the only property, Stridhan was as much as what a man would hold. However, with the advent of agriculture, now a dominant position acquired by the menfolk, the land became to be held by men because the land was something which they had to protect. And a woman would get married and go out of her tribe to another tribe. So, in order to avoid the fragmentation of land holdings, the laws probably evolved to say that, okay, she also has an equal share, but let her be given that share in kind. So she was given various movable properties or cattle, and it was supposed to be by way of an equal share. What the total share was of immovable, movable, this was supposed to be given as equal share to her, and it was supposed to be her property. So when you see the earlier smritis, Yajna, Valkya, and various other commentaries which basically followed Yajna Valkya, you would find that earlier the term Stridhan was being interpreted in a very broad, liberal way. So it meant inheriting property and out of share or purchase. And however, later on, we find Manusmriti. Manusmriti was considered to be much less liberal to women. And Manusmriti was one of the smritis which became the main source of Hindu law. So Manu Smriti writes that, it says that na stri swatantra maharti swatantram na kachit striye, meaning that women were unfit for any independent existence. So Manu Smriti laid down the general perception, which was at that time of battles and small wars which were coming about, that a father protects a woman in her childhood, husband protects her in her youth, and sons protect her in her old age, and a woman is never fit for independence. So it is not that all Hindu Shastric law wanted to interpret it in this way, but because of socio-economic conditions, the interpretations as sounded most logical at that time of Manu Smriti, they came to be adopted and interpreted later on. So this is how, however, at this time, I may pause and say that in Kerala and some southern states, matriarchal system, matrilineal system, whereby property devolves from mother to daughter from the woman's side, that continued. And it is found even today in certain parts of Kerala and various places of South India. So Marumakkatyam was the law, and the other one was Alisantana law, Marumakkatyam. So in Marumakkatyam law, it was primarily in Kerala. The household consisted of mother and children with joint rights in property. The lineage was also female line. Daughters and their children were an integral part of the household. Likewise, in an Alisantana system, the name of the mother's ancestral house used to be the prefix or suffix. When you carry a name forward. This was because the men used to go out to the battlefield, and the women took the wife took the entire responsibility of the family and was the decision maker. However, in most part of India, what was applicable was Mitakshara law, and Daya Bhaga was applicable around Assam, Bengal, etc. So gradually, when Mitakshara law became more evolved, and with the changing time periods, when we go to the medieval periods, when more invaders started coming in, it also came to be the Stridhan underwent another change. So while earlier woman was seen as the owner of his Stridhan, now it became that she was never the absolute owner of his Stridhan. She began to be denied property rights to hold ancestral or marital landed property. And in fact, Manu also suggested that because a wife belonged to her husband, so her property also belonged to her husband. In fact, it was a suggestion that what she earns when she is maiden, when she is unmarried, will belong to her, and when whatever she acquires after her marriage will belong to the husband. And this thought process was not only individual to India. In fact, you will find texts, the references to it, even if you talk about England, the English laws, the common law land, they have specific references that how the woman would also be treated as the property of the husband. So when you see laws like adultery, which now has been decriminalized, adultery, the offense was also couched in a language as if to say that adultery is a crime to another man if you commit adultery with his wife. It was not about women. So this was the thought process which carried on. And the ancient scriptures, strangely, don't really mention any landed property for unmarried women. And Mitakshara and Daya Bhaga, out of that, while Mitakshara was more stringent and claimed that a co-parsoner's share in a joint family property, the women will have could never be a co-parsoner, and a widow of a deceased co-parsoner also was not given any rights to either enforce partition of a husband's share against his brothers. Property rights of women were very, very restricted. And according to Daya Bhaga, however, this was in Bengal and Assam, as I stated earlier. If there were no male descendants under the Daya Bhaga law, then a widow could succeed to her deceased husband's share and enforce partition. But Here also, women were not treated as absolute owners of property, because they could sell property only for limited legal necessities and not for other reasons. So on the death of a woman, that particular property would revert to the nearest male heir of the deceased and did not pass on to her female heirs. And this is called reversionary rights. So it used to pass on to the reversioners, not to any of the woman heirs. So the Istri Dhan also developed by and by, and after that Istri Dhan, another concept came about, which was the woman's estate. So during the Britishers' time, in fact, it started from the medieval period, when there were Muslim invasions. Then it was thought that instead, if a man would die without an heir, it was decided that it was best to keep the property as the woman's estate, which would thereafter revert back to the other male reversioners after her demise. So, the Bombay school, which studied Mitakshara and deliberated upon it, defined it as the Stri Dhan would be what she inherits from her own parents, what she gets from her own parents or from her own labor prior to marriage, and what she gets from her husband's side of the property would not be considered as a Stri Dhan at all. So, this also had various permutations and combination, what kind of Stri Dhan she could exercise control on, what she could not do. And overall, it became more and more the wealth of the assets of a widow were not regarded as the assets of the widow or the woman. They came to be regarded as the property of her husband. So this was the entire scenario. And so the economic status, the declining economic status, in fact, gave rise to a very inferior social status also. So when you have referred in your query that on one hand the goddesses, they were treated as goddesses, and on the other hand, why such an inferior status? Because if you are not economically sound, your status will be inferior. Even today, you can see this is a hard fact, a hard reality of life. So Manu Smriti would say that there were 4 varnas. Women were considered to be below all 4 varnas also. So gradually, with the medieval period, when there were Muslims and there was a threat of acquisition of a property of a man who died issueless, then the limited estate was given, but which gave a further rise to socio-religious crimes such as sati. So if a woman would acquire as a limited estate, the moment she would die, the reversioners would get the property. So it led to crimes like sati, like bigamy. It was recommended, in fact, in the text, that if you do not have a son, then you adopt a son. So the adopted son had superior rights to your own daughters. So these were the sexual crimes and crimes against women that gradually came up. And so this is how the progression, socio leading to economic, and so on and so forth, and the legal rights. Yeah.
As rightly pointed out by ma'am, that the position of women started deterring with the changing social economic position in the society. Ma'am, can you please throw some light on the legislations made by the Britishers, since we're talking about the ancient era, which has led to or which impacted the inheritance and succession laws for women?
Okay, Khushbu, those Britishers, unlike what is generally thought, that the entire legislations or maybe amelioration of women property rights happened in the British time. So it is not the case, but the Britishers did start certain, they did bring about certain legislations to abolish practices like Sati Regulation Act, So a lot of reformers, Indian reformers, also had a role to play, like Raja Ram Mohan Roy. And sati and other such malpractices were also punishable under the Indian Penal Code, which was in 1860. Now, what created limited rights for widows? There was one particular enactment, which was Hindu Widows Remarriage Act. They permitted Hindu women to remarry. And then the most prominent legislation they took out was in 1937, which was Hindu Women's Right to Property Act. Now, this particular act, it established Hindu women's rights over landed properties inherited from male owners, but to a limited extent again. So this act recognized three categories of widows: interstate man's widows, the widow of a predeceased son, and a widow of a predeceased grandson. So these widows were given a share in the undivided interest of the Mitakshara co-parcenary. However, in spite of all of this, the Shastric, now very conservative Shastric laws survived. And although 1937 Act, it established limited rights for Hindu women in their interstate husband's property, the biggest flaw was that it could never guarantee any rights to women's successors. When the deceased had disposed, the deceased could have earlier also disposed of his property by will, which would take effect. And the share of agricultural women was not touched upon. So basically, this enabled the widow to succeed along with the son and to take the same share as the son. But she was entitled only to the limited estate. The widow could not be a co-parcener. She could, and a daughter had virtually no inheritance rights at all, and they could not sell or mortgage property except for legal necessity, or for religious, or with the consent of the next reversioners, which consent was never forthcoming. In fact, reversioners would wait to see her die so that they could get the property. And even in Widows Remarriage Act also, if she got remarried, she would lose the right to the property. So that also, so these were very suboptimal kind of rights that the women finally got. So these are the acts I can think of with regard to the prominent ones, which pertaining to women. Of course, Britishers enacted various other legislations, but these 3-4 legislations are prominent and relevant with regard to women.
Yeah. So, ma'am, does that mean that the step taken for this equality, gender parity, they started post-independence era?
Yes, in fact, the main protagonist of women's right was, one of them was B.R. Ambedkar. The other name which comes up is Renu Chakrabarti. So there were a lot of debates. So on the eve of independence, when Hindu Code Bill was floated, and it was suggested, so the Constituent Assembly, during the Constituent Assembly debates, those are rather interesting to read, because what was actually suggested by B.R. Ambedkar was what came about in 2005. So the changes, more or less, so the changes suggested were that the widow, daughter, widow of a predeceased son, all to be given the same rank as the son in the matter of inheritance. The daughter was also prescribed to be given a share in her father's property, ancestral, the agricultural property too. The share, although even at that time, they suggested that why should she not be given, at least give her half to what the son would get. And they try to balance it out by saying that, okay, if the succession of Stridhan is there, then the son would get half to that of a woman. Although women, as you know, hardly would have any properties to give. So these were the suggestions made in the bill. And the Hindu Code Bill was therefore the first step towards giving more equality. However, this created quite an outrage, A lot of Hindu section, vast majority of Hindu sections opposed the Hindu Law Committee and their report, and there was there was a huge concern about how the foundations of Hindu society were attempted. There was an attempt to change the foundations of the society, and thereafter, very interesting that the Federation of Indian Chambers of Commerce, FICCI, there's an article which is referenced in the archives in 1955. So there is an article which says that if the daughter gets a share equal to that of son, so it would aggravate the evil of fragmentation of agricultural holdings. And this could be, it was suggested that this could be avoided by a wise use of testamentary power, and so that neither urban business families nor agricultural families would be prejudiced. So therefore, there was a lot of outrage at what was being suggested, and finally, the various amendments were proposed. There was a suggestion to incorporate the right to will under Hindu Succession Act, which was totally opposed. Although by that time, Indian Succession Act 1925 had already was already there. It was also formulated by the British, and it was much more gender neutral. It to till date it retains that much higher gender neutrality, especially after its amendments. But this did not find incorporation in Hindu Succession Act. So when Hindu Succession Act came about, simultaneously you find a host of Hindus related legislations besides Hindu Succession Act 1956. You see Hindu Marriage Act in 1955. You see Minority and Guardianship Act, and you see Hindu Adoptions and Maintenance Act. So all these bunch of enactments came about. And when the Hindu Code came about, the scheme of Hindu succession was largely based on Rao's committee, which was also one of the committees which was asked to give its report. And although it purportedly was enacted to remove the inequalities between men and women, but what it let's assess what it did. So perhaps one could say it was the first blow to the gender inequality which persisted at that time, and it almost abrogated, not completely, but mostly abrogated the rule of survivorship. The rule of survivorship was only now applied with respect to undivided share in Mitakshara property of Mitakshara Kopasana who died intestate. And Section 8 of the Act, the legal heirs were defined, Section 8 and Section 15. Women still were kept out of the co-pasanary. They could not be a co-pasaner. So Section 6, which was earlier and further amended by 2005, it provided that only men would be the male descendants would be the co-parceners. Then thereafter, there was no right for devolution of co-parcenary interest by will. So this was a later section which was incorporated, by amendment or by adding Section 30, that the devolution of co-parcenary interest was also provided by will. And then it recognized the right of a child in the womb also, that the moment a child would take birth, even though inside the womb, he would have the same rights to inherit. Now, most important with reference to women was that there was an enlargement of the limited estate of a woman into absolute right. So Section 14 of the Hindu Succession Act, the legislature gave to a Hindu woman an absolute ownership. It converted the limited right of a woman, limited interest of a woman into an absolute estate. While there was a proviso to it, where if a woman was given property with specific rider, that it was to be exercised in a limited way and in a manner given. Unless that happened, by virtue of Section 14, the woman came to hold all the property absolutely, and the possession, the interpretation of possession, which she possessed, the term was which she possessed in a limited way, would turn into absolute property. So there was a liberal interpretation of the term possession. Now, for this also, there were several Supreme Court cases, and finally, the Supreme Court observed that the expression possessed in Section 14 was to be used in a liberal, broad way. Possession could either be actual or even constructive or in any form as recognized by law. Rather, they said that the proviso, the limited understanding would be, limited interpretation would be given to the proviso rather than the main clause. So 1956 definitely made a headway, but it quite fell short of giving equality amongst the two genders. Perhaps one could say at that time the society, the social setup was also not ready to accept such far-reaching changes. However, why it should have taken so many years from 1956 to 2005 and multiple judgments on these very issues to bring about such changes, I am unable to understand. And in fact, there's a very interesting incident. It's not that the entire Hindu society used to be always so rigid or conservative. So there is a chronicle of one Mr. K.C. Sharma, who moved for an amendment, who made a representation to the law minister for the then law minister, saying that that should include daughter and her children also as in the Hindu co-parsonary, just like a son and the children. The then law minister rejected the same outright and said that, I think my friend Pandit K.C. Sharma is very progressive in his outlook, and I cannot imagine a family which can go on smoothly by addition of daughters, their heirs and so on. It is admitted that a daughter does go out of family by marriage. So when this was the mindset, so against that backdrop, perhaps 1956 was quite an achievement by the lawmakers. But even now, the agricultural lands could not devolve upon the women. And Section 4 to Clause 2, Section 4, Clause 2 of Hindu Succession Act restricted the devolution of agricultural land to women. So this was later repealed again by 2005 amendment. So now if
starting from...
Yeah, no. I'll just complete, I'll just add on that
yes,
Section
please.
23 was another section which I wanted to mention. So Section 23, which is now repealed of the Hindu Succession Act, that stated that took away the right of female rights, prohibited females to claim either partition of the dwelling house or even to reside unless they had been deserted by the husband. So an unmarried woman would have the right to reside only, but of course not to claim partition. But an unmarried woman did not have even right to reside unless unless she had been deserted. Here I also want to, I'm sorry, I'll take 2 more minutes on this. There were various state amendments later on. I'm jumping to 2005, but I think I should touch upon various state amendments which southern states came about with. First was Andhra Pradesh. Now, Andhra Pradesh said that it recognized the rights of daughters and said that, but avoided mention of unmarried daughters. So it said that the daughters are equal to those of son, and it granted co-parsonary rights to daughters. This was followed by Tamil Nadu, that was followed by Maharashtra, Kerala, and perhaps it was all a result of the influence of Maruma Kattam and Ali Santanan laws, that influence which was still there. Then thereafter, a couple of commissions came about. Dowry Prohibition Act also came about, which kind of try to clarify that Stri Dhan is the sole property of women only. But and it was followed by, because people would again camouflage. It was a very thinly differentiated line, because earlier the trend was that dowry had started, and it came to be known as if it was the Stri Dhan was to the couple, not to the to women. So there was this issue was settled finally by the Supreme Court in Pratibha Rani case, where it said that Stri Dhan will remain the only that of a woman, and not it cannot be taken over by the husband at all. And then we find 2005 Amendment Act. In the 2005 Amendment Act, we see the prominent section which was amended was Section 6, where finally women were given the status of co-parceners. Women became the equal active members of co-parcenary property. They could become karta now. They could exercise their right to partition. And no matter what, she was given the right to inherit. However, now we see what happens in 2005. By this time, the laws had undergone so much of change and interpretation by the courts, that you would find there's hardly any ancestral property, the HUF property left. So if you see 2005, it although gave certain rights, but as they say, justice delayed is justice denied. So I think a lot of women have just gone through hardship without exercising their rightful rights in the property. Yeah.
Yes, ma'am. Starting from Vedas to 1956 Act, then the 2005 Amendment, and then today the recent judgment which we have, that is Vineeta Sharma's. We have come a long way with respect to women's rights under inheritance and succession laws. And if we talk about the judgment also, they have touched upon various issues which were pertaining to 2005 Amendment also. So what do you have to say about this particular judgment? How is it going to impact the women's in the coming future? And is it that actually the time to celebrate the victory, or we have a long road ahead to actually cross before we come to that point of celebration?
So, Khushbu, victory, I think it has to be construed for the entire society, not only women, because each man is connected to several women in his life, mother or wife or a friend or sister. So it has to be seen as a victory of a social setup. So I would say yes, a victory to the extent of at least a paper recognition of what should have been there centuries back. But yes, it is definitely a very, very huge step forward. And so after this also, in fact, after 2005 enactment, the Amendment Act, there were certain conflicting judgments again. Now, there was one case by Supreme Court Gurupad Khandappa, and there was another one, Prakash versus Phulavati, and then the Manna case, where there was a lot of ambiguity, where so there has been an ambiguity that 2005 Gurupad was earlier. This was pre 2005, and these two judgments, Prakash versus Phulavati and Damanna, these are post 2005. Now the issue arose whether this 2005 amendment was retrospective or prospective in its application. Now, while Prakash versus Phulavati, and firstly, let's talk about Gurupad, why I'm referring to a pre-2005 judgment. This was a 3-bench judgment of Apex Court, which said that notional partition its logical conclusion by assuming that actual partition had taken place. So it translated the deemed partition or notional partition into as if it is an actual partition. So thereby destroying the joint family, joint Hindu family, and crystallizing the shares of the members of the joint family. Now, after 2005 Amendment Act, there arose certain questions whether Section 6 was retrospective or prospective, whether Section 6 would apply in case the father, who was the co-parsoner in the joint Hindu family, was not alive on the date. So therefore, the partition would have taken place upon his death due to notional partition. Whether the pending probate proceedings or partition suits, etc., what would be the status of those proceedings in the light of the amended provisions, and on the oral partitions also, whether they were to be excluded completely. Now, Vineeta Sharma has clarified this position and has answered this query by saying that neither are these amendments retrospective nor prospective, but it confers benefits on females retroactively. So legislation applies retroactively because it is prescribing certain benefits conditional upon an eligibility, which eligibility, Vineeta Sharma says, came about by birth. So retroactive legislation application along with 2005 amendment would make applicable to female successors the benefit of succession on par with that of her male counterparts based on an event which has taken place prior, that is her birth. So therefore Phulavati, the Prakash versus Phulavati has been overridden to that extent, and so this is basically the status. And however, the right of succession of female successors now that it comes about unequivocally, we find that a lot of instances may not be even available to women to claim any of their rights. And even where alienation has already taken place or partition suits have been decided, then the Limitation Act would kick in. So a lot of women, if they wish to claim any benefits which are still available, that is, so they have to take care that they should not become time barred. And there also will be a larger, because the Supreme Court has said that any pending suit or appeal involving the controversy around the application of Section 6 of Amendment Act must be disposed of not later than 6 months, in accordance with Vineeta Sharma verdict. So now the question will arise, what happens to those appeals which are pending and have arisen out of final decree on the basis of the pre-2005 law. So these are the issues, and of course third-party rights have been created, and this will also have an impact on the laws existing in a lot of southern states. As I said, a lot of southern states gave the status of equal co-parceners to unmarried daughters as on that day in 1980s. Now what will happen is that perhaps this would have an impact of overruling various state laws, the interpretation of 2005 read with Vineeta Sharma case. So this is a little, there are a few confusions which Hindu Succession Act is anyway very used to facing, and I'm sure there will be further deliberations and more judgments to watch out for. Thank you.
Ma'am, at the passing of this 2005 amendment and the recent judgment, has women now been given a complete equality status, or we still are lacking behind somewhere? Some work still need to be done.
So I think if you see all women-related legislations, I think we still have a long distance to cover, and I would say that either the Supreme Court should appoint a committee, or there should be a wholesome amendment of the rules which still require equalization. For instance, I'll give you one of the case laws, which is Om Prakash versus Ramachandra, in which this is about a woman. Now, this is a very famous case which will tell you how gender equality comes about. This is a very atypical case which would apply to several other similar situations. Now, there was a woman who got married and moved into her matrimonial home. Her husband died within 3 months of marriage. The marital family discarded the woman, this woman, Narayani Devi, I think was her name, from the matrimonial home. So she returned back to her parents, who supported her, provided her with for further education, provided her with funds, and she started working. She amassed substantial property. So when she died childless in after a few years, and she predeceased her parents. Now the same people, her matrimonial, her in-laws, who had thrown her out, they claimed Narayani's property. And the brothers and of Narayani properties, in fact, it was decided that they were the rightful heirs to her property. This is by virtue of the gender disparity which is there in Hindu Succession Act. If you read Section 8 for men, the succession for men, and if you read Section 15 for women. And now, if you take exactly the same situation, and if Narayani was a man, this injustice would not have occurred, and the property would have remained with the man's family if Narayani Devi were a man. So Section 8 and Section 15(1), they also require deliberation, and in fact there are courts which have justified this existing gender disparity. So while Section 8, when a male Hindu dies intestate, it devolves in a manner of different classes given. First, on class 1 heirs, which is wife, mother, children, and children of predeceased children, etc. And if no class 1 heirs, then it goes to class 2 heirs. So class 2 heirs are also again the father's side of the family, the deceased siblings, the siblings' children, and all of that. And then if there are no heirs over there, then amongst the agnates, which are the male line, and then cognates, which is the mother's line, fathers, and then thereafter the mothers. Now, if you see Section 15(1), 15(1) talks about devolution of the property of a Hindu female when she dies intestate. So, firstly, the property would devolve on children and husband, and then if there is no husband or children, then it would devolve on the heirs of the husband. And so what has been defined in Section 8 as meaning heirs of the husband, it would devolve on them. And if there are no heirs of husband, then upon the woman's parents. And if there are no parents, then again the heirs of the deceased father, and then the deceased mother. Now, if you see that a woman whose husband has died, a widow, if you see, I think Hindu Marriage Act, when it comes to the maintenance of such a woman, either it has to be done from the estate of the husband. Otherwise, it is not the in-laws' estate, which can be first approached. The parents of the woman will have to look after her if she is not able to look after herself, if she has no means. So first, a woman has to have means. If she doesn't have the means or the estate of the husband, then the parents. And thereafter comes the role of the women, of the in-laws, to maintain such a woman. So there is clearly, there is neither a logic nor a parity, very clearly. So besides this, there are several other laws one can see, and these are absolutely in the teeth of Article 15 of Constitution of India, which prohibits that any sort of discrimination on the basis of gender, sex, or any of those criteria. Then the international conventions which India has joined, it is a signatory to various international treaties and conventions which call for equality. We have Indian Succession Act in front of us. That is a more gender equal legislation still. And interestingly, this issue came up before several courts. So Bombay High Court decided there are conflicting judgments. One says it is constitutional and it justifies it because of the patriarchal setup, and the other one says it is unconstitutional. It is now referred to a division bench, and I think this matter has also come up before various conflicting judgments on this. And I think after now Vineeta Sharma is there, and another judgment recently passed yesterday on the shared household. I think we should hope that the Honorable Supreme Court should take this also as the next agenda. And one more thing, there were two amendments have been moved in 2013 and 2015. One was by Anurag Singh Thakur and one was by Dushyant Chautala. They moved bills to equalize this with certain suggestions, but these were not taken up. These could not be taken up for discussion, and ultimately they lapsed. The bills lapsed. So this is how the situation is.
Yes, ma'am. Thank you so much for imparting so much knowledge to us, and we are highly, highly honored to have you with us. At the end, I would request you to please conclude by few sentence or words, if you have to say about exactly the position of Hindu women's under the inheritance and succession laws in India.
Okay.
Your concluding
see,
remarks.
I've already given you the background, the current position, and all of that. This is what I would say, that as I have demonstrated that an economic independence and the economic power goes to the root of your social status. So I think, when women, whether Hindu, Muslim, or any other religion or society, I think they should take this issue of being economically independent and empowered very, very seriously. So a lot of young girls grow up on fairy tales like Snow White, that you will be living happily ever after you get married, or there will be a Prince Charming coming to rescue you. All that is not the reality. So I think if you're independent and if you face so you don't even need the property of anybody. You don't need the property of that husband. You don't need the property of the parent. You are yourself empowered enough to earn it. So my parting repartee would be that laws on one side make yourself so well equipped that men fight over your properties and you don't have to blame any shame. That is my point.
Right, ma'am. Absolutely rightly said, because we have seen n number of people screaming for legislations, not only with respect to women's right, but in general. Anything happens and they start demanding legislation. But the point is, till the time you are not vigilant enough for your own rights and you do not stand for yourself, the legislation cannot help you in any which way. And either it's a man or a woman, it is very important now that you are well educated, you stand for yourself,
Absolutely.
and you work for yourself. The more you are dependent on others, the more vulnerable you be. So if you want to come out of that vulnerable section of the society, then you need to work on yourself.
Absolutely.
And then only probably the laws will be able to help you out. Right, ma'am?
Yes, absolutely. So even if the laws have been given to you, but how are you going to claim them in any case? Because you are
Right.
still dependent on those, on several sections of society which would not want you to get your share. So ultimately, unless you are empowered, you get nothing. So
Right.
laws are definitely facilitators, and we are definitely, one should be very happy about the legislative equality which is happening, and we hope
Right.
it continues to happen and happens very fast for the remaining inequalities also.
Yes, ma'am. And the role of judiciary is obviously, we all know that the legislations were enacted, but it is the role of the judiciary which has helped us to keep on changing and amending the legislation according to the changing needs of the society, so that they are just even at present, and are able to justify the needs of the people. So, with that note, I would extend my vote of thanks to you. And it was an honor to have you with us. I honestly have done my master's in family law and I love the
Okay.
subject. But
I didn't know
listening
that.
from you,
That's
I
wonderful.
was like, oh shit, ये तो मैंने पढ़ा ही नहीं था कभी. So it was like really a very, very nice experience, very knowledgeable. And I'm very grateful to you. I hope we connect soon again for some other sessions, and we would love to listen from you again on another topics. Thank you so much, ma'am, for being with us, and thank you to the viewers. We'll see you soon with the next session. Till then, bye bye and good evening.
Thanks so much.